Business Law 1, welcome to Lucky 13 in our contract series, and we're still talking about consideration. And we were talking in our last segment about the types of statements that cannot be consideration, all right? And we started with past consideration, right? Pre-existing duties, past consideration, and now we're going to move on to the area of illusory promises, all right? And so an illusory promise is basically a promise that doesn't have any substance, right? There is such uncertainty of performance that the promisor has not definitely promised to do anything. If the promisor can't be pinned down as to what they've actually agreed to do, that promise is said to be illusory, without consideration, and unenforceable. So the example here, the president of Tuscan Corporation says to his employees, all of you have worked hard, and if profits remain high, a 10% bonus at the end of the year will be given if management thinks that it's warranted. Two ifs in that statement create a level of confusion, right? But even one of those ifs in that statement, so let's read it again. The president of Tuscan Corporation says to his employees, all of you have worked hard, and if profits remain high, whatever that means, a 10% bonus at the end of the year will be given if management thinks it's warranted, whatever that means. You see? Either one of those are asking for a meaning, right? Asking for definition. Hopefully one of the things that you've gotten out of this class so far is that language is important. And the more precise it is, the less confusion you will create. And that's true throughout, from contracts law to torts law, product liability, and constitutional law where we started out. So the reason this is an illusory promise, or in fact no promises at all, is because performance depends solely on the discretion of the president of the company, right? The management. There is no bargain. They can't work harder to make sure that they get that bonus. They can't have a certain target, right? Profits remain high, right? Is that an 8% margin? 16% margin? A 24% margin? Is that a dollar figure, right? A dollar figure of revenue, or dollar against gross expenses, right? Is that a dollar figure of net profit? None of that is clear enough, right, to be able to pin the president of that company down. Certainly I hope that if profits had continued at their then current levels, that they would in fact give them a 10% annual bonus. But as it stands, that promise is an illusory one because there's no bargain in exchange, bargain for consideration. The statement declares merely that managers of the company may or may not grant a 10% bonus or something in the future. And so there is a chart in the book that details and sort of sets out some of the factors that sort of define these agreements that lack consideration. They can still be agreements, but they don't have a consideration, so they're not contracts, which means they're not enforceable, right? Pre-existing duty, past consideration, illusory promises, those three, right? Now let's talk about the impact on certain types of agreements. So there are many types of contracts. We've talked primarily about contracts that govern transactions so far, but let me talk about a couple of other types of contracts and how they might be impacted by these rules. First, there's a thing called an accord and satisfaction. So an accord is simply an agreement to pay a debt, and a satisfaction is the payment of that debt, right? An accord only comes up when a debt has not been paid and it needs to be paid. So generally when there's an allegation that a party is in breach or is about to be in breach, that's when the accord comes up. And the accord is the agreement to pay that debt, often for an amount that's less, right? It would be an agreement specifically to pay a debt for less than what's owed. The satisfaction is The satisfaction is a technical term that describes the payment part, the execution of the accord. Remember that an executed contract is one that has been completed, right? When that execution occurs, then that accord is said to be satisfied. That's accord and satisfaction, right? The accord is only a contract if the amount of the debt is actually in dispute. If we both agree that I owe you $1,200, right, then an agreement that I will pay $1,000 instead is not supported by consideration, right? But if you say I owe $1,200 and I say you calculated the interest all wrong, I should only have to pay you $900, right? And then we say, okay, well, we'll agree that I'll pay you $1,000, right? That is a dispute over the amount of the debt, and so that's why you get to have an accord and a satisfaction, right? With regard to accords and satisfaction, that's really the main rule. There are a couple of other types of contracts that are also where you also need to be aware, including releases and covenants not to sue that we'll get to. But before we get to that, if a debt is liquidated, right, then accord and satisfaction can't take place. A liquidated debt is one whose amount has been ascertained, fixed, agreed upon, settled, or determined otherwise, right? It's only a disputed claim that can be subject to an accord and satisfaction. But if the amount of the debt can be said to be unliquidated, right, there's some unclarity about that amount. It's not set, fixed upon, agreed, or determined, right? And reasonable persons could disagree over the amount that's owed. Then acceptance of a lesser amount agreed to by the parties operates as a satisfaction of an accord, or also known as a discharge of that debt, all right? So, next, let's talk about releases. A release is a type of contract or contractual provision in which a party forfeits or gives up the right to pursue a legal claim for whatever reason against the other party. It bars any further legal action beyond, and bars, in addition, any recovery for the counterparty other than what's specifically described in the release. All right, so let's take a case. Let's say that we engage in a transaction and a legal dispute arises due to that transaction. Actually, no. Let's say that we engage. I'm about to engage in a transaction, right? And a potential for a legal dispute exists, right? Let's say I'm about to ride on Elon Musk's rocket ship, which I think would be a really cool thing to do, right? I'm going to ride on Elon Musk's rocket ship, but the amount of, we don't know, they haven't had much space liability, and Elon Musk's staff, right, wants me to release all claims, right, other than, say, they have a liquidated damages clause that basically says, if you die in outer space due to our negligence, you will be limited to X dollars as compensation. Your estate will be limited to X dollars as compensation for this result. That's known as a release, right? 3 requirements. Good faith. The agreement must be made in good faith. This contract has to be signed, cannot be oral. In many states, it's part of its statute of frauds requirement. And it has to be accompanied by consideration, meaning that a release is no good if there is no bargain for exchange, separate from whatever the transaction is. You have to have a transaction for the release that might be separate from whatever that main transaction might be. All right? It's often a contractual provision, like if you go and do, the last time I went to a ropes course, which was kind of like a executive kind of thing where you do this physical stuff. You're climbing over obstacles and swinging on ropes and whatnot. that had a release, right? It's separate from the actual acquisition of the ropes training, right? There's included in it is a release provision, right? That is, that's that. So here's an example. Kara's car is damaged by an accident caused by Raul's negligence. Raul offers Kara $3,000 if she will release him from further liability resulting from the accident. Kara agrees and signs the release. If Kara later discovers that the repairs will cost $4,200, she can't sue him because she's already settled or released that claim. She wasn't in litigation, so we called it a release instead of a settlement. But it's basically like a settlement of legal claims. She can't sue for the additional $1,200 because she's already released Raul from that. Kara and Raul both voluntarily agreed to the terms of the signed writing, and sufficient consideration was present for the release, if not for the actual repairs. The repairs are not the subject of their contract. The release is the subject of their contract. All right, the consideration was the legal right to recover damages that Kara forfeited should her damages be more than $3,000. That was in exchange for Raul's promise to pay the $3,000 immediately. All right, then there's a thing called the covenant not to sue. It sounds a little bit like a release, right? But it's unlike a release because it doesn't always prevent further recovery. All right, the parties simply substitute a contractual obligation for some other type of legal action based on a valid claim, right? So suppose in the prior example, which is the car accident between Kara and Raul, Kara agrees not to sue Raul for damages in tort action if he will pay for the damages to her car, right? Settled, right? If Raul fails to pay, then Kara can resume her lawsuit because that's a covenant not to sue, and the payment by Raul, if made in full, is the consideration that supports the covenant not to sue, right? But if it's not in full, then that agreement actually just disappears and does not function like a release, and she can then resume with her lawsuit. And this then brings us to our next topic, all right? So what happens if something is not consideration? We know one of the consequences is that thing will not be a contract, right? And then there is this notion of promissory estoppel, right? Because sometimes individuals end up relying on promises that are made even if they're not responsible, right? I mean, even if they're not legally sort of bound, right? And their reliance can form the basis to sort of infer certain rights and duties even though a contract may not be present, right? So under the doctrine of promissory estoppel, which is also called detrimental reliance, it almost describes the rule, right? A person who has reasonably and substantially relied on the promise of another can obtain some measure of recovery. It is not necessarily a contract recovery. Promissory estoppel is a quasi-contractual, although using it slightly different context. We were describing it in our classification of contracts introduction, right? Promissory estoppel involves detrimental reliance. Someone is doing something in reasonable reliance upon the promise of another. All right, for promissory estoppel, several things need to be true, all right? 5 elements. 1, a clear and definite promise. Clear and definite, not wishy-washy, not maybe so, not if, right? A clear and definite promise. The promisor should have expected, meaning based on the circumstances, the person who's making the promise should have expected the other party to rely on that promise, right? The promisee, the person to whom the promise is made, reasonably relied on that promise. If they do so unreasonably, that's going to kick them out of recovery land, right? So they acted or refrained from some act based on that promise. Reasonably, right, relied on the promise by acting or refraining from an act. 4, the promisee's reliance was definite and resulted in a detriment. That's what we call a detrimental reliance. If I don't go to this job because you promised me that job, right, I've lost money to my detriment. I avoided the other job to my detriment, right? And then fifth, injustice is avoided by enforcing the promise. This is a quasi-contractual style recovery, right? It's just not one based on unjust enrichment, right? It's based on detrimental reliance, all right? Once these requirements are met, the promise can be enforced even though it's not supported by consideration. In effect, the promisor, the one who made the promise, is estopped or stopped. But basically, legally, we talk about estoppel because the person is estopped, meaning that they are prevented from denying the effectiveness of the promise, right? It doesn't cease them from doing something that they're doing, right? It sort of enforces the promise, which until that point may in fact be intangible. It's similar to the doctrine of quasi-contract. I kind of call it quasi-contract, except for it's not technically the same thing, but it's pseudo quasi-contract. Quasi-contract is based on the unjust enrichment of one party because they took a benefit, right? Promissory estoppel is similar, right? It's also equitable, it's also non-contractual, and it's based in the party's detrimental reliance upon the hard promise of another. So, I promise to pay you $1,000 a week so that you'll not have to work, right? If the person doesn't work, right, and you promise to pay them $1,000 a week, like you want to keep a mistress or something, right? On some level, that's promissory estoppel, right? Another example, I promise to contribute $50,000 this year to the All Saints Orphanage, right? Well, they probably need that money, and they're probably going to go out and make some purchases in reliance upon the fact that you're going to make that gift. And if you fail to do so, they are going to experience a serious detriment, like a shortfall of $50,000, right? So just answer the prompt below and then be prepared to move on to the next one. Thank you very much for your time. See you next time.